So we're here today on warrant number 2019 SW17. Kevin Jack, is that Chamaty? Chamaty?
Chamaty.
Say it again, please, ma'am.
Chamaty.
Chamaty. And also warrant number 2019 SW18, Michael Chase Havard.
Yes, ma'am, Your
And
Honor.
for purposes of the record, if the attorneys, including the state, place your name on the record, please.
Your Honor, Allison Sesby, District Attorney on behalf of the state of Georgia.
Your Honor. And Mr. Chamaty, who is
And I am Brett Mizerak, or Mizerak, M-I-Z-E-R-A-K. And I represent who will be sitting to my left.
And, sir, would you please spell your name again? Please?
Yes, ma'am. It's Mizerak, M-I-Z-E-R-A-K. Sorry.
All right.
Your Honor, as this matter was scheduled before the court, I believe last Thursday, we have spoken to defense counsel in this case and indicated for the purposes of scheduling that Special Agent Jamie Abercrombie with the Georgia Bureau of Investigation had a conflict today. She is testifying in a murder case. Based upon that, defense counsel has agreed and stipulated that we may proffer a factual basis regarding this case since Agent Abercrombie is unavailable.
that is fine on behalf of Mr. Chamaty.
And that is correct on behalf of Mr. Havard.
Go ahead.
On or about December 3, 2018, Lakota Ricky Clore, Stephen Blake Dye, Hunter Nicholas Hill, Dalton Levi Manuel, Kevin Jack Chamaty, and Michael Chase Havard agreed to commit an armed robbery and murder of Justin McKinney for the purpose of acquiring marijuana and pills, the property of Justin McKinney. Said armed robbery and murder were to occur at 135 L. Georgia, the residence of Justin McKinney. Defendants entered into said agreement at Lakota Clore's residence, which was located at 10157 Old Highway 76, Morganton, Fannin County, Georgia. As part of the conspiracy on December 4, 2018, defendants Dickey, Hill, Manuel, and Lakota Clore traveled in Lakota Clore's pickup truck to Justin McKinney's residence to rob and murder Justin McKinney. As further part of the conspiracy, Lakota Clore remained in his pickup truck and traveled on Elrod Road near Maple Grove in Fannin County, Georgia, to serve as the getaway driver after the crimes had been completed. As a further part of the conspiracy on December 4, 2018, defendants Dickey, Hill, and Manuel entered into Justin McKinney's residence to accomplish the murder and armed robbery. On December 4, 2018, defendants Dickey, Manuel, and Hill possessed firearms at Justin McKinney's residence to accomplish the armed robbery and murder. Specifically, defendant Dickey possessed a .410 shotgun, defendant Manuel possessed a .25 caliber handgun, and defendant Hill possessed a firearm with being a .380 caliber. Lakota Clore had provided defendant Hill with said .380 handgun. At the time of the armed robbery and murder, Justin McKinney and Anna Franklin, persons and human beings, were also inside Justin McKinney's residence. On December 4, 2018, at Justin McKinney's residence, defendant Dye shot Justin McKinney in the back of the head with a .410 shotgun, killing him. As further part of the conspiracy, on December 4, 2018, at Justin McKinney's residence, defendant Manuel shot Anna Franklin with a .25 caliber handgun in her neck and arm with the intent to kill her. Anna Franklin survived the attack. Although defendants committed the act in furtherance of the conspiracy with intent to take marijuana and prescription pills, the defendants did not take said marijuana and prescription pills when they left the residence. While Lakota Clore was waiting for defendants Dickey, Hill, and Manuel to return, Lakota Clore's pickup ran out of fuel. On December 4, 2018, Lakota Clore used his cellular telephone in Fannin County, Georgia, to call defendant Chamaty and to request defendant Chamaty and Havard provide defendant Clore with fuel so that Lakota Clore could drive defendants Dickey, Hill, and Manuel away from the crime scene. Defendants Chamaty and Havard agreed to provide said fuel, knowing that said fuel would be used to accomplish the cover-up phase of the conspiracy by transporting defendants Dickey, Hill, and Manuel away from the crime scene. In furtherance of the conspiracy on December 4, 2018, defendant Chamaty and Havard traveled to Lakota Clore's residence in defendant Chamaty's vehicle. While at Lakota Clore's residence, defendant Havard retrieved a fuel container. At that point in time, they traveled to the gas station located at the Lakewood intersection on Highway 515 in Morganton, Georgia, went to Pump 9, retrieved fuel from that location, and then defendant Chamaty and Havard purchased the fuel to fill the container and traveled to Lakota Clore's location and assisted Lakota Clore in refueling his vehicle. Later on December 4, 2018, and actually if I could back up, prior to defendants Chamaty and Havard receiving the telephone call to retrieve fuel from Lakota Clore, all 6 individuals had previously been located at Lakota Clore's residence. At Lakota Clore's residence, there was discussion.
That same day, or?
That would have been on December 3rd. There was prior discussion regarding the intent to quote unquote pop and rob Justin McKinney. Pop, of course, was established to mean to kill, meaning that Chamaty and Havard had prior detailed knowledge of the robbery when they decided to obtain gasoline and take it to Lakota Clore's vehicle as he was waiting for defendants Hill, Manuel, and Dye to return. After they had arrived on scene at 135 Elrod Lane to assist Lakota Clore in refueling his vehicle, defendant Chamaty did walk to the residence at 135 Elrod Lane, and at that point in time did make contact. And I apologize, that was Havard, correct? Excuse me, that was defendant Havard that left the scene, walked towards the residence at 135 Elrod Lane, and identified Levi Manuel, Hunter Hill, and Blake Dickey exiting the actual residence of Justin McKinney and Anna Franklin. At that point in time, all leave the scene in Lakota Clore's vehicle with the exception of Kevin Chamaty. This is immediately following the attempted armed robbery and the murder. They then stop both vehicles. Certain individuals stay within Lakota Clore's truck. Other individuals get into Kevin Chamaty's vehicle. They travel in separate directions and meet back at Lakota Clore's residence. After they meet back at Lakota Clore's residence, Lakota Clore attempted to remove the serial number from the .25 caliber handgun that defendant Manuel had used to shoot Anna Franklin. Lakota Clore did so with the intent of covering up the crimes, and in furtherance of the conspiracy on December 4, 2018, defendants Chamaty, Havard, and Clore leave Lakota Clore's residence in defendant Havard's vehicle and travel to Lake Notley in Union County, Georgia, where Lakota Clore disposed of the .25 caliber handgun by throwing it into said lake with the intent of concealing the .25 caliber handgun from law enforcement. This was done with the knowledge and participation of defendants Chamaty and Havard. As the court is aware, previously, Lakota Clore entered into a negotiated plea regarding his involvement and participations in the crimes as previously set forth. I believe, as was previously announced in court, it is the state's intent to present this case to grand jury immediately in this upcoming week, as the grand jury in Fannin County will be reconvening. And at this point, the state is opposing bond as to both defendants Chamaty and Havard.
Let me ask one question. You may have said it, I didn't know you. Why did these two defendants not go with the other four?
My understanding at the time that the four defendants left the house, that they were going to leave the house, defendants Chamaty and Havard made a decision to go to Walmart. Once they were at Walmart and not initially participating in, at first traveling to the residence at 135 Elrod Lane, that is when they received the call from Lakota Clore that he had ran out of gas and would they bring him gas, at which point in time they go to Lakota Clore's house, get a gas canister, go to the gas station, and then travel in the vicinity of 135 Elrod Lane to meet Mr. Clore while he is waiting on Manuel, Dickey, and Hill to return from Justin McKinney's residence.
Was there any affirmative act on their behalf to say, I'm not going to do this when the other four left, or was it just decided to go to Walmart?
Your Honor, and I apologize, and I certainly do not want to misrepresent anything, and as Special Agent Abercrombie isn't here.
Okay.
I can certainly speak to my understanding that at that point they had disengaged themselves from participating. However, reinserted themselves with bringing the gasoline. They stayed on scene at 135 Elrod Lane for a period of time. And in fact, while they were waiting on Hill, Manuel, and Dickey to return from 135 Elrod Lane, had traveled to another residence in an attempt to kill time before they traveled back to the vicinity of 135 Elrod Lane. At which point in time, defendant Chamaty parked in the parking lot of a church nearby to wait. Defendant Havard then exited Lakota Clore's vehicle, walked through the woods in an attempt to find and locate Manuel, Dickey, and Hill, which is when he did see them exiting the residence and did identify and put firearms in the defendant's hands as previously stated.
All right. Thank you. All right. Mr. Steele.
Good morning, Your Honor.
Good morning.
Your Honor, we have several people here who have come on behalf of Mr. Of course, permission, I was going to call some witnesses and then tell the court about his Mr. Chris Hyde.
Yes.
Raise your right hand. Do you swear or affirm to testify in the county, state of Georgia versus Mr. Kevin Chamaty, Fannin County warrant number 2019 SW17 before the Honorable Judge Weaver will be the truth you got?
I do.
Please have a seat, make yourself as comfortable as you can.
Mr. Steele, let me do two things while we're on the record. Is your client away? And I know you did this last week, but to make sure it's on the record, your client had waived his right to have this, even this bond hearing heard in Fannin County, and agreed to have it heard here today in Pickens County, because I was going to be here most of the week. Is that correct?
That is true. For purposes of this hearing, Your Honor, we waive venue.
It,
Same waiver of venue for Mr. Havard as well.
Thank you. And Ms. Sosby, I did not ask you this, but was the alleged victim, Ms. Franklin, notified about the hearing being moved to Pickens County?
Yes, Your Honor, contact was made not only with Miss Anna Franklin, but also with Miss Catherine Greenway, the sister of Justin McKinney, and Deborah Vignardi, the mother of Justin McKinney, and they will not be present here today.
Oh, thank you. Go ahead, Mr. Stover.
Please have a seat. Make yourself as comfortable as you can. Once you do that, would you do me the courtesy to state and spell your name for this honorable court?
Chris Hyde, C-H-R-I-S-H-Y-D.
And can you tell this honorable court the background of yourself, where you were born, raised, educated, what you do for a profession?
I was born in Bradley County, Tennessee. I was raised in Copper Hill, Tennessee. I currently reside in Whitworth, Georgia. I attended high school at Copper Basin High School. I graduated from college at Cumberland University in Lebanon, Tennessee. I currently am a business owner in Fannin County. I've had a tile installation business for somewhere around 17 years.
And have you ever been convicted of a felony?
No, sir.
And do you know the gentleman who is seated to my left?
I do. Kevin is my stepson.
And how long have you known Mr. Chamaty, who you identify as Kevin?
Pretty much his whole life, since he was in diapers.
And you understand the charges that we face that brings us here before this honorable court?
Yes, sir, I do.
And you understand the sentences that are imposed for a felony murder case, don't you?
Yes.
And that carries, I told you, did I inform you?
Yes, sir, you did.
Okay, the death, life in prison without parole, or life with parole, which is 30 years at least. You understand that?
Yes, sir.
Okay. Understanding that, please tell this honorable court, on your oath, if granted bond, where could Mr. Chamaty reside?
He will live with me.
And who else would be in that home?
His younger sister, his brother, his mother, and myself.
And if this honorable court ordered that Mr. Chamaty, if granted bond, cannot be around any firearms, would you ensure that there are no firearms in your residence?
Yes, I would.
And if this honorable court deemed it appropriate that Mr. Chamaty's passport, if any, to be surrendered to the authorities or to my office or to the court while bond is in place and this case is pending, would you ensure that that occurs?
Yes.
Is there any passport to your knowledge that Mr. Chamaty currently has?
No, there is not, to my knowledge.
And would you ensure that there is none applying for if bond is granted?
Yes.
And if granted bond and this honorable court had certain people who Mr. Chamaty could not associate with, have contact with, potential witnesses in this case, would you ensure that those people do not come around your home or have contact with?
Yes.
How about a job? If granted bond, are you aware how Mr. Chamaty will either be working or going to school or both?
Hopefully both. It would depend on his bond conditions to what he could do as far as work goes. If he could travel out of town to work or if he had to stay within the county to work. So that would be something that would be arranged once we learn stipulations of his bond.
Either, if this honorable court sees fit to grant bond, either way, he would be gainfully employed either locally if the court didn't want him to leave or outside the jurisdiction if the court permitted.
Yes, sir.
But he'd have a job.
Yes.
And what type of work would he be doing?
He would be doing labor work, construction work, possibly tile work.
And that's with you or
Yes.
one of your friends?
Yes.
And if the court wanted to know where he's working with the district attorney's office, that information would be provided.
Absolutely.
And his hours of work.
Yes.
How about school?
I do believe, I can't say 100% sure, but I do believe that application has already been put in for him to re-enroll in night school.
Okay. And that is to get his high school diploma?
Yes, sir.
And he was already doing that prior to his arrest at some point?
Yes.
In order for this honorable court to determine whether a bond should be granted, this honorable court has to go through certain issues. I'd like to discuss those 4 issues with you, okay?
Yes.
Knowing Mr. Chamaty since he's been in diapers, on your oath, is your opinion as to if granted bond and was released from custody, that Mr. Chamaty would come back to court when required, meaning he would not flee the jurisdiction of the court?
I believe 100% that he would return,
Without hesitation?
without hesitation.
If granted bond, do you have any reason to believe or evidence or even a suspicion that Mr. Chamaty would be a danger to any person in this community?
No, I do not.
If granted bond, do you have any reason to believe or any suspicion that Mr. Chamaty would be a danger to any property in this community
No, I do not.
or in any community?
No, sir.
If granted bond, do you have any evidence or supposition to believe that Mr. Chamaty would obstruct the administration of justice?
No, sir.
Do you have any evidence or reason to believe that Mr. Chamaty would intimidate a witness if granted bond?
No, I do not.
Do you believe or have any evidence to share with this honorable court on your oath that if granted bond, a felony, a misdemeanor, or any crime while out on bond?
No, sir.
Mr. Hyde, would you be willing to put up your own wealth if this honorable court determined it appropriate?
That is my intention.
Well, let me finish. The honorable court could also write that you would lose that wealth if Mr. Chamaty violated any condition of bond. Would you be willing to put up your wealth
Yes,
without hesitation?
without hesitation.
The Honorable District Attorney may have questions for you or this honorable court. I want to thank you so much. Thank you, Your Honor.
Ms. Sosby.
Mr. Hyde, I have just a couple of questions to you. On December 3rd, 2018, you,
No, ma'am, he was not. No, that is prior to the event, correct?
that would be
December
the
3rd?
incident date.
Huh? On
That would
said
be the
date?
incident date.
Okay, no, ma'am.
And how long had it been since he had resided with you?
I cannot say for sure with 100% positivity. 2 months? A month? No more than a year, for sure.
And where had he been residing prior to that point in time? Where had he been residing prior to December 3rd, 2018? Do you know?
It is my understanding possibly at Mr. Calor's, but I'm not 100% for sure.
So you didn't have daily contact with him to know where he was residing then, correct?
Correct, not daily, but he came by the house whenever he felt to do so.
Now, how old is Mr. Chamaty?
He is 20 years old.
Now, he did not graduate high school, correct?
That is correct.
When did he stop attending high school?
I could not tell you the exact date that he stopped attending high school.
Do you know if he was a freshman,
I think that he
sophomore,
was
junior?
a sophomore by grade, but possibly a junior by age, if that's what you're looking for.
And when he stopped attending school, was he residing with you at that point in time?
Off and on he did, yes.
Okay, where else was he living if he wasn't living with you?
He was staying with his mother, to my knowledge.
Okay, and where was that located at?
I think it may have been off of Scenic Drive.
Now, you reside at 335 Queen Road, correct?
Yes, ma'am.
And you resided there for a number of years.
Yes, somewhere around 17, I believe.
And you have, how many children do you have?
I have 4 children, 2 biological and 2 stepchildren.
And your biological children, I believe that you had indicated are Cahetta and Ivy?
Yes,
And Cahetta is in high school, Ivy is in middle school, correct?
correct.
They reside in the home with you.
Yes, they do.
And your stepchild is the defendant in this case, Kevin Chamaty, correct?
Yes.
You are not married to their mother,
No, I am not.
and you have not been for a number of years, correct?
Correct.
But you indicated that she actually resides back in the home with you.
Yes.
And so who resides in the home with you at this point in time at 335 Queen Road?
As stated before, the defendant, his mother, myself, and his younger brother and sister.
Now, when did Mrs. Hyde move back in the home with you?
Cannot remember the exact date. More than a year, possibly.
And during that time, Kevin was in and out of the home, correct?
Yes.
Now, the defendant, Kevin Chamaty's mother, has a prior criminal history, is that correct?
That is.
And she previously went to prison.
I do not think she went to prison, ma'am, no.
She served her time in the Fannin County Jail.
Yes.
She was convicted. Are you aware of what her convictions were?
No, I'm not. Not verbatim, I am not.
Were they drug related?
I believe they may have been.
Where was Kevin working as of December 2018?
Either Brotherhood Oil or one of the like HVAC companies in Blue Ridge. I can't remember exactly which one.
And are you aware as to whether or not he's ever been arrested?
I am
Prior
not
to
aware.
this?
I'm not aware.
So you did not know that he was arrested in 2017?
I know that he had a speeding ticket that he possibly didn't get paid in time at that point, if that is what you were referring to. Speeding ticket or seatbelt ticket, I believe.
And where would he be working now when you indicated if he were to be granted a bond in labor or construction?
I would employ him if he were not able to go and work out of town.
What is Mrs. Hyde's first name?
Her first name is Heather, but
What's her name?
everyone is going to call her Christy. But her first name is Heather.
Christy Neiman Hyde, is that correct?
Heather Christina Hyde, I believe.
Can I have 1 second, please? And Mr. Hyde, that Mrs. Hyde was convicted of possession of methamphetamine and possession of a firearm during the commission of a felony with a 15-year sentence in October of 2015?
I said that I was not aware of the complete specifics of that. I know that there was an issue, but I do not know the complete specifics, no.
I have nothing further at this time.
Thank you, Your Honor. May I ask you just a few more questions, sir?
Yes.
Okay. If this honorable court ordered that Mr. Chamaty live with you, you're agreeable to that?
Yes, sir.
And if Mr. Chamaty then decided, I'm not going to live here, you would alert me, the district attorney, and this honorable court if the court deemed that appropriate?
Absolutely.
Okay. Now, the 2017 incident that the honorable district attorney just referred to with Mr. Chamaty, do you remember that being a seatbelt violation?
It was not a major thing, I do not think.
Okay. Okay. And then Mr. Chamaty's mother, she's in the courtroom,
Yes, she is.
and she moved out from your home. Is that fair to say? At some point?
Yes, at some point.
And she had a drug problem, right?
Yes.
And how long have you known Mr. Chamaty's mother?
The crib, maybe? Possibly would not have known her then, but I am aware that we played in cribs together as children.
And even though the two of you divorced, for the children, you still try to maintain a family unit. Is that fair?
Yes.
And you let freely Ms. Hyde live in the house
Yes, I do.
and keep your name.
Yes.
And when Mr. Chamaty's mother was going through the 2015 incident, that didn't involve you at all with the drugs, did it?
No, sir, it did not.
And she's in drug counseling and getting help, and she's drug-free now, is that fair?
Yes.
And she's working?
Yes.
And how long has she been working?
Several years, or since everything happened, she has been steadily working.
And the prosecutor stated, and she may be right, my understanding is different, but let's hear your understanding, that Mrs. Hyde has been convicted. Is she under what's called the First Offenders Act? And if you don't know, that's fine.
I believe that she is, yes.
Okay. And she's on probation.
Yes, sir.
And you're aware that there could be no firearms in the house while on probation, no drugs in the house. You're aware of that?
Yes, sir.
And what would you do if she had a relapse and had drugs in the house? Would you alert somebody?
Yes, I would.
Especially if the Salmon Court allowed her son, your stepson, to come home?
Yes.
Okay. All right. And when Mr. Chamaty wasn't living with you, that's because his mother took him out of the home. Is that fair to say?
Yes.
And that disrupted his high school
Yes.
career as well?
Mm-hmm.
You've been stable.
Yes, sir.
Okay. I want to thank you so much. Thank you, Your Honor.
Ms. Sedgwick Cross.
If I could have 1 second, Your Honor. Your Honor, I have what has been marked as State's Exhibit 1, and I would like to tender that. It is a copy of the sentence and indictment as it would relate to Heather Christina Hyde, Superior Court of Fannin County, case number 2014 R279. It is my understanding there would be no objection from Mr. Steele. And I would like to clarify, yes, and that's why was one of the purposes of tendering this. She is sentenced under first offender.
And that's correct, no objection?
For purposes of this hearing, Your Honor, no objection.
Admitted without objection.
Mr. Hyde, Mr. Steele had asked you that you would remove firearms from the house. Are firearms currently located in the house?
No.
Okay. Now, prior to the defendant's arrest, Mr. Chamaty's arrest, he was located in Raleigh, North Carolina. Do you know why he was in Raleigh, North Carolina?
I know he went to see a friend, to my knowledge.
That friend being Mr. Chase Havard that's seated at the table next to him?
Yes.
And do you know how long he was there?
A couple of days, and then when he was notified that he had to come home, both of them came home from Raleigh.
Nothing further.
Your Honor, may I follow up just on that last bit?
Yes, you may.
Apologize. Just because the prosecutor asked you, may I just follow up on that last bit of
Yes, sir.
information? When you said to the Salmon Court, once Mr. Chamaty had to come home, can you tell the Salmon Court why he had to come home?
The police had shown up at my house and met with his younger brother and said that he had, I guess, is it a warrant for his arrest? And so he was notified. He returned home on his own will.
And then, did Mr. Chamaty turn himself into the sheriff of Fannin County?
Yes, sir, he did.
And was that voluntarily done?
Yes, it was of his own will.
Okay. And do you remember the day that Mr. Chamaty turned himself in to the Fannin County Sheriff's Office?
I do not remember the exact date, but I do know that it was the Monday that the GBI agent asked him to be there.
Okay. And the Sunday, late afternoon, early evening, before last Monday, do you realize that Mr. Chamaty's been in custody for approximately a week today?
Yes, sir, I do.
Okay, so it's about last Monday he turned himself in?
Yes.
The Sunday afternoon before that, were you with your stepson
Yes.
And whose office, if any, points were you at?
In Mr. Steele's office.
Is that me?
Yes.
Okay. And did I contact your knowledge, the GBI agent, and advise that we would voluntarily turn ourselves in that Sunday or Monday?
Yes, sir, you did.
And it was agreed Monday morning?
Yes, sir.
And to your knowledge, did Mr. Chamaty come through with his word and voluntarily turn himself into custody?
Yes, he did.
And he's been in custody since?
Yes, sir.
Thank you so much. Thank you, Your Honor.
Anything further from this witness?
Nothing for
Let me step down, thank you.
Thank you.
Call your next witness.
Your Honor, we would call Mr. Gerald Patterson, G-E-R-A-L-D-P-A-T-T-E-R, S-O-N. Please raise your right hand. Do you swear or affirm the testimony you're about to give in the Superior Court versus Kevin Chamaty, SW 17, before the Honorable Judge Weaver will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Please make yourself comfortable, have a seat, and do me a favor, once you are set up, please state and spell your name for this honorable court.
My name's Gerald Patterson, G-E-R-A-L-D-P-A-T-T-E-R-S-O-N.
And Mr. Patterson, would you do me the courtesy and educate this honorable court on education, profession, and then how you know Mr. Chamaty if you do?
Okay. I was born in Copperville, Tennessee, graduated from Copper Basin in '71, moved to Atlanta, worked in the private sector basically for about 45 years, and now I'm retired and do some courier work and driving for Mountain Valley Motors in Blue Ridge, Georgia. I've known Mr. Chamaty's grandmother for my whole life, and we have really gotten together in the last 5 years. We lived together, and I just consider everybody in her family part of my family.
And that would make Mr. Kevin Chamaty what to you?
I guess a step-grandson.
Okay. And what did you retire from? I know you said 45 years.
I was in sales, worked at Sears and Roebuck for over 20 years, Graves Fireplaces in sales for 15 years, and some other building material sales jobs, basically.
And do you have any prior criminal history?
No, sir.
And you understand what Mr. Chamaty is charged with?
Yes, I do.
And do you understand why we're here today asking this honorable court to consider setting a bond for him?
Yes, sir, I do.
Over the last 5 years, how close have you become to Mr. Kevin Chamaty?
I've watched Kevin, I met him there in his early teenage years, and I guess around 14, 15, and basically been around him at numerous family functions, ball games. We'd see him in town, small town, so you run into people, and just basically all family activities.
And on your oath, do you have any evidence or reason to believe, even if it's just remotely, that if granted bond, then Mr. Chamaty will flee the jurisdiction of the court? That means he will not come back to court.
No, sir, I do not believe he would flee.
He's coming back.
He would come back, yes.
If granted bond, on your oath, is Mr. Chamaty a danger to any person in this community or any community?
No, sir, to my knowledge, or what I believe, I do not think so.
On your oath, and how you know Mr. Chamaty, if granted bond, do you believe that he would be a danger to any property in this community or outside the community?
No, sir, I do not.
If granted bond by this honorable court, do you have any evidence to share or believe that Mr. Chamaty would obstruct the administration of justice, bribe a juror?
No, sir, I do not think so.
If granted bond, Do you have any reason to believe that Mr. Chamaty would intimidate a witness?
No, sir, I do not.
If granted bond, do you have any evidence or belief that Mr. Chamaty would be a risk to commit a felony or any type of crime while out on bond?
No, sir, I do not think he would.
And you said many times, I do not think, on your oath,
Yes.
are you firm that Mr. Chamaty would comply with all conditions of bond and return to court when required?
Yes, I'm firm with that.
So firm that are you willing to put up your own wealth for bond for Mr. Chamaty, knowing you would lose that wealth if this honorable court fashioned the order of bond if Mr. Chamaty violated any condition of bond? Are you willing to do that
Yes, sir, I would.
without hesitation?
Yes, sir, I would.
I want to thank you so much, the prosecutor and this honorable court. You may have questions.
Yes, sir.
Ms. Sesby?
Mr. Patterson, I have just a few questions for you today. Where did you indicate that you resided? What is your
Oh,
physical
I'm sorry, I didn't
address?
say, I live in LJ, Georgia for the last 20 years.
Okay. And who resides in the home with you?
Rachel Newman, Mr. Chamaty's grandmother.
And do you have anyone else residing in the home with you?
No, ma'am.
Now, Mrs. Newman, I believe as you had indicated, is previously from the Copper Hill area in Tennessee, correct?
That's correct.
Is this the same Mrs. Newman that was convicted in 1990 of voluntary manslaughter for the shooting death of her ex-husband?
Yes, ma'am, it is.
Excuse me, would you say that again?
The same Rachel Newman that was convicted in 1990 of voluntary manslaughter in the shooting death of her ex-husband, Robert Newman.
Thank you.
Now, Mr. Patterson, you said that you have resided in LJ for how long?
Since 99, right at 20 years.
And you are not married to Miss Newman, but the two of you cohabitate, you reside together?
That's correct. That's correct.
Because I have made an indication that
We are not married.
the defendant was your step-grandson, so I wanted to clarify.
Yeah, not legally, I'm saying.
Now, you indicated that your interaction with Mr. Chamaty is that you would see him around town and you would see him in family activities, correct?
That's correct.
Over the last 5 years.
That's correct.
And how did you feel about the fact that he had dropped out of school, being a sophomore or junior?
We're concerned, we wanted him to get his education, so we were concerned, hoping, that he would get his education.
Did you or Mrs. Newman ever make any efforts to attempt to make him return to school?
Yes, we've talked to Kevin, yes.
To no avail, he didn't go back, correct?
I was aware that he might have been at trying to get his GED. It's kind of where I was with it, yes.
And you heard the prior testimony that they have made an application for him to get that? But,
Yes.
and were you aware of what his living arrangements were? Where did you think that Mr. Chamaty was living prior to this incident in December 2018?
I thought he was maybe in Epworth, but I knew he stayed on the old 76 some also.
Old 76 being 10157.
I'm not sure the address, but I think so.
Lakota Clore's house?
Yes.
And Lakota Clore actually, at the time that this occurred, was 16 years old. And Mr. Chamaty was living in Lakota Clore's home, even though there's a 4-year age difference. Is that correct?
I didn't know myself, but maybe yes, I don't know.
And what was your understanding of why he was residing with a 16-year-old?
I thought maybe he was trying to work and there was several of them there, so I just thought maybe they were trying to figure it out.
When you say several of them there, what do you mean?
Several kids there, or I've known of several being there.
Living at Lakota Clore's house?
Not sure about living, but they would be there some, so.
So you didn't have any, I guess, so to speak, control over Mr. Chamaty's decisions in terms of residing with Mr. Clore or him dropping out of school, correct?
That's correct.
You do not have a granddaughter of Mrs. Newman that resides in the house with you?
No, not today. Rachel has custody of her. She's staying in Blue Ridge
Okay.
at this moment.
And what is her name?
Randy, Randy Newman.
Randy Newman. So your wife Rachel has custody of her daughter, her granddaughter Randy, but she's not residing in your home right now.
That's correct.
And why does your wife have, how old is Randy?
Randy is 17.
And why does your wife have custody of her?
Her dad is incarcerated and mother's just not able to do it.
And he's actually incarcerated in federal court on drugs and firearm charges, correct?
That's correct. I think he's actually in Polk County now, state maybe.
Polk County, Tennessee.
Yes.
And you indicated Rachel is who we refer to as Christy Hyde. That is, Rachel is her mother, correct? And it is also Mark's mother. And
That's
she has
correct.
custody of his daughter.
That's correct.
Can I have 1 second, Your Honor?
Next.
I have nothing further at this time, Your Honor.
Mr. Steele?
Thank you, Your Honor. The last gentleman that the Honorable Prosecutor asked you about, who's in federal custody,
Yes.
to your knowledge, that's not Mr. Chamaty's father, is it?
No, sir.
That has nothing to do with Mr. Chamaty, right?
That's correct.
Thank you so much. No other questions, Your Honor?
Ms. Sosby, anything further from this witness?
Nothing further, Your Honor.
Ms. Upton, thank you. Call your next witness.
Your Honor, in the interest of judicial economy, I was going to ask if I could turn my back for a moment and just ask everyone to rise who has come here to support bond for Mr. Chamaty instead of calling all these people, if that's okay.
All right, go ahead.
If you would do me a courtesy, if you would please stand in your place if you have come here today to support bond being granted for Mr. Chamaty. Would you please would return to court when required to do so. Please remain standing if you believe that if granted bond, Mr. Chamaty would not be a danger to the property in this community or any community or a person in this community or any community. Please remain standing if you believe that if granted bond by this honorable court, Mr. Chamaty would not commit a felony or any crime while out on bond. And please remain standing if you assert Mr. Chamaty would not intimidate a witness or otherwise obstruct the administration of justice. I want to thank you all so much. Please have a seat with the court's permission. Your Honor, I didn't count it, to be quite frank, the court, but maybe 20, 25 to 30 people who stood for that entirety of that location. Your Honor, Mr. Chamaty, as you know, is 20 years of age. He has not finished high school. He is enrolled and has been enrolled in the Mountain Education Charter High School. That's an online, Your Honor, He was last enrolled this past fall 2018. His family has told me that, as the court heard, that he's in the works of re-entering if the court grants bond. Your Honor, the facts here, they're unthinkable. Nobody is in any way diminishing loss of life for any person or living creature. But here we stand before this court in a position where Mr. Chamaty is cloaked with the presumption of innocence. And under Ayala, which is AYALA versus State 262 Georgia 704, 1993, the Honorable Supreme Court of Georgia has articulated that more blood has spilled in the state of Georgia, an original colony, to defend the presumption of innocence than for any other reason. And therefore, if Mr. Chamaty can come forward with compelling evidence to satisfy this honorable court that if granted bond, he would not flee the jurisdiction and return to court when required, he would not be a danger to a person or property in his community, he would not obstruct the administration of justice, he would not intimidate a witness, and he would not commit a felony while out on bond, and all of that is significant risk of doing it. I didn't ask it that way, I just said any belief. Then the presumption is that bond should be granted unless the state can produce evidence that there are no conditions of bond that are sufficient to permit Mr. Chamaty to be given the opportunity to live on bond while he defends the case. Your Honor, I have spoken with the Honorable GBI Agent Abercrombie. She's very, very nice. I've texted with her. I can show you the text. If the court wants to see it, I can show it to the district attorney. I've offered. District attorney's office has been nothing but professional, as they always are. I was first introduced to this matter 2 Sundays ago, so that would be the 10th day of February of 2019. Mr. Chamaty and his family came to my office. He was with both of his parents and his sister. And he explained that he just had returned, as you heard, from Raleigh, North Carolina, because he heard there was a warrant. He needed to turn himself in. I contacted the sheriff's office. I was told it's a felony murder warrant. I contacted Agent Abercrombie. She said that's correct. And I said we could turn Mr. Chamaty in tonight or tomorrow. She said tomorrow would be fine. She asked me what time. I told her the time. We were in constant contact. She texted me about 10 o'clock, said, where is Mr. Chamaty? I said, he's at the Fannin County Jail. She said, okay, great. To claim that Mr. Chamaty is a risk to flee the jurisdiction is hard for me to understand under that situation, because I have been with people who do flee or have fled, and it's horrible and it's wrong. But they usually don't hear about a warrant, turn themselves in, and get a lawyer. It shows that Mr. Chamaty and his family are going through the legal process in the correct way. As far as being a danger to a person in a community or property in the community, we are presumed innocent in this crime. The Honorable District Attorney has stated, I knew this already, that they have evidence that Mr. Chamaty actually withdrew from any type of conspiracy to commit an armed robbery, conspiracy to commit any harm or pop or hurt anyone, and that's why he was not with the other people. I know the court was told that today pursuant to the court's question. So the issue will become, if we even get indicted, which I hope we don't for felony murder, but the issue will become, are we a principal or a party to this crime by bringing gasoline and getting rid of a gun, or are we an accessory after the fact? And that's going to be an issue that the jury will resolve one day, and it's a huge issue for us, but at this point in time, there is no reason to believe that Mr. Chamaty is a danger to a person or property in his community being presumed innocent. My understanding, and if the district attorney corrects me, that's fine, but Mr. Chamaty has had 1 arrest, and it's for a seatbelt violation in 2017. That is it. That's what I'm told. If I'm wrong, obviously, I will stand corrected. As far as obstruction of administration of justice, I don't have any evidence of same. In fact, I have evidence contrary. Agent Abercrombie told me, as well as the district attorney's office had told me, two representatives for the state of Georgia sitting at the table in this honorable court's room, and told me Mr. Chamaty actually has come in and met with the GBI and has been substantially of assistance to them in this case. And that's why Mr. Chamaty was advised the privilege, and it is a privilege, it's not a good privilege, but the privilege of turning himself in based upon his word and my word. The GBI chief told me that as well. So he has, instead of obstruct the administration of justice, he has done the opposite. I know the state will argue that allegedly getting rid of a gun and obliterating, helping or knowing about the obliteration of a serial number is not exactly the mark of somebody who's not obstructing justice. However, we are presumed innocent, and the subsequent acts of Mr. Chamaty after that supposed incident with the gun shows that he has actually a different frame of mind. As far as intimidating witnesses, I have never been told by anyone that during this period of time, we have over 2 months, that Mr. Chamaty in any way has tried to contact or intimidate any witness. And then the risk of committing a felony, has no prior felony record whatsoever. And I understand that you heard about a gentleman in federal prison for drugs that has no relation to Mr. Chamaty. I understand that you heard about his grandmother being convicted of voluntary manslaughter. I was told actually that that was a insanity plea, but I may be wrong. But anyway, that happened in 1990s. Mr. Chamaty wasn't even born. His grandmother's here if you have any questions, but that shouldn't have any resolution and enlightenment on Mr. Chamaty's bond. And then you heard about his mother, and his mother did definitely go through a struggle with illegal contraband and drugs, and she left the home, or was kicked out of the home of Mr. Hyde. Mr. Hyde, really a great person, has taken in a family. He's not even married to Mr. Chamaty's mother, but yet he lets everyone live together under the cloak of a family unit, and he would give you his oath, and he would, court can obviously order it, that if there is any drug use or anything where Mr. Chamaty does not follow condition bond, he would certainly represent that to the court. Mr. Hyde is a pillar of this community, has been in business since the last 17 years. And to me, he's done everything right. He's taken in a family that has at times struggled, and he has continued to support them and is willing to put up his own wealth. Mr. Patterson, he considers Mr. Chamaty his grandson or step-grandson, and he's willing to put up his wealth that he has accumulated over his lifetime on the bond. Your Honor, I would respectfully ask the court to please grant bond. The district attorney's office is truly amazing. They've kept me in contact, so does Agent Abercrombie, and I appreciate them waiving the venue. I appreciate this court having this hearing today, and we would respectfully request that a bond be set in any and all conditions that the Honorable Court believes are appropriate. I would ask for education and or work so that Mr. Chamaty is being productive, never being around any guns, no contact with other of the co-defendants or the witnesses in this case. And I'm not a big believer in ankle monitor, but if the court is, an ankle monitor will be paid for by the family at their own expense. And that Mr. Chamaty could have pretrial services reporting. He could have reports of pretrial services. If the court wants to do that, I will be in constant contact with him. I give my oath that if something changes on that, I will alert the court right away. And I would ask the court to grant a bond. I believe that all 4 prongs of the Ayala versus state test has been satisfied by Mr. Chamaty. Thank you.
Ms. Sosby.
Your Honor, relying on the case that was cited by Mr. Steele in his argument for bond, being Ayala versus the state, pursuant to OCGA 17-61E, the trial court may release a person on bail if the trial court finds that the person, 1, poses no significant risk of fleeing from the jurisdiction of the court or failing to appear in court when required. 2, poses no significant threat or danger to any person, to the community, or to any property in the community. 3, poses no significant risk of committing any felony pending trial. And 4, poses no significant risk of intimidating the witnesses or otherwise obstructing the administration of justice. In the factual proffer that was given to the court at the beginning of this hearing, it is alleged that Mr. Chamaty is actually currently charged with felony murder, party to a crime, for criminal attempt to commit an armed robbery. He is alleged to have been aware of what was going to occur at the residence of Justin McKinney, and to Anna Franklin, that he voluntarily facilitated the commission of those acts by not only going to Lakota Floor's house, getting a gas can, going to the gas station to retrieve gas, going all the way to the scene, but stays there, participates, gets out of the car, goes and looks for the 3 defendants that made entry, and as the factual basis had said, following that, participates in taking those defendants away from the scene back to Lakota Floor's house, at which point in time he helps facilitate and participate in the destruction of I will say, the attempted destruction of a .25 caliber handgun by participating in going to Lake Notley, where that firearm was thrown in the lake with full knowledge of what had occurred. The questions that were asked of Mr. Hyde and Mr. Patterson, I can assure the court, I take no pleasure in addressing any of those issues with the witnesses that were on the stand. But we have a 20-year-old individual that cannot be accounted for in the time frames 2 months to 1 year of where he was residing prior to December of 2018. He may have been over at Lakota Floor's house. He may have came by at 335 Queen Road. No individual that came to testify before this court today exercised authority, or if they did attempt to exercise authority, had the ability to successfully exercise authority over Mr. Chamaty. It is no different now than it was then. We have a 20-year-old individual that had dropped out of school, either being a sophomore year credits or a junior year credits. We have an individual who is 20 years of age, at least part-time residing in a resident with 16-year-old boy. It is not a tenable situation. There is not anything that has changed from then to now, except for what the state alleges is participation in what resulted in felony murder and a destruction or attempted destruction of a key piece of evidence. There is no better indicator of the future than what has occurred in the past, and that's what this court is presented with. It is a very difficult situation, but in terms of the individuals that testified for him, neither one of those are related to him by blood. We have the Mr. Patterson, an individual that dates the defendant's grandmother. We have the ex-stepfather of the defendant that has testified, but no familial relationship has been presented. Mr. Steele does an excellent job presenting his case. He is a wonderful lawyer. He did have everyone in the gallery stand up in support of Mr. Chamaty, and I have no doubt that that is exactly what they would do, since they would be present here. But as the court can note, there are several juveniles that are in this gallery right now. As a matter of fact, we have the sister of Lakota Floor, who is present in the gallery now, here in support of Mr. Chamaty. the connections, the continuation that Mr. Chamaty has with the witnesses in this case have not ceased. When he was advised that he had a warrant, he was actually located in Raleigh, North Carolina, out of state, with the individual seated at the table with him, Mr. Havard. There's no testimony regarding true employment status of the defendant. He may have been working side jobs here and there. According to his Facebook post, he is a former at nowhere for his employment status. All of these things the court has to take into consideration. Employment status. Was he enrolled in school? Certainly wouldn't appear from the testimony that was presented by Mr. Hyde that he was actively involved in school, even seeking his GED. We have no stable place of employment. We do not have him actively enrolled in school. And in terms of his ability to reside in certain locations, the one that has been proffered to the court is in a home with his 2 minor half-siblings and his mother, who is not married to his stepfather, residing there, and she is currently serving 15 years probation under first offender status for possession of methamphetamine and possession of a firearm during the commission of a felony. As the court can note on what has been admitted as State's Exhibit 1, those were not the only charges. That was done on a negotiated plea, also including crossing the guard lines with drugs and possession of methamphetamine with intent to distribute. The nature of the charges in this case are serious. The state is opposing bond. The state would argue that he does pose a significant threat or danger to a person, to the community, or property in the community by virtue of the actions which he is alleged to have committed. We would argue that he does pose a risk of committing a felony pending trial by looking at his past conduct in terms of, and as well as obstruction in the administration of justice for willfully advising and participating in destroying a key piece of evidence in a murder investigation. Thank you.
Well, the court, in looking at this case, both in this case and the individuals that are charged with all the other charges, it is just amazing to me that taking responsibility for any of these children growing up, just living wherever they need to be. The court does look at the difference in what the others are charged with compared to these, although certainly after the fact they started participating. It does appear that they, prior to, they made a decision not to do that. It's very troubling. Again, frankly, I just am not real happy with the parents or the grandparents of any of these children, because they obviously just let these children grow up wherever. The mom participating in drug-related activities and on probation. And, okay, this is what I'm going to do. I am going to set a $50,000 bond, of which Mr. Hyde, who testified, and Mr. Patterson, who testified, will sign on. So both would be responsible for making sure that he comes back to court. He must reside with Mr. Hyde. So for example, if Mama decides she wants to move out, that's fine, but he must stay with Mr. Hyde who testified, who I don't think has a criminal record, or he didn't introduce anything.
He does not.
And Mr. Patterson, I don't think had a criminal record.
Neither one do, Your Honor.
Must reside with Mr. Hyde, period. If for some reason that is not working out, then that could not be changed, to the court changed it. Which probably at that point in time would be Mr. Patterson. In other words, the two people that testified that don't have criminal charges, who appeared to the court, would make sure they come back. They would have whoever in Mr. Hyde's home would can't anyway, if his wife is living there, but absolutely no firearms in the home. He would be under house arrest except for working with, again, Mr. Hyde, period. If Mr. Hyde's gonna have to go out of state, then he can't go. In other words, he will not be allowed to leave the state of Georgia, but he will be allowed to work with his stepfather in the presence of his stepfather. And under house arrest, except for that work, going to church again, if they go, with Mr. Hyde, or medical appointments in which Mr. Hyde will be responsible for taking them. He'll have no contact with any of the co-defendants, and that means text messages, telephone calls, Facebook or email, zero contact. With any of the other co-defendants, he will have no contact with any aunt or their families. In other words, sister or Thor, I don't know what the relationship is, but that, no contact. That contact with the others is what I think got him in trouble this time. So no contact with the co-defendants or any of the family members of the alleged victims in this case. He'll be on the color wheel. That means he'll call in every morning to determine what color comes in that day. Any positive screens, he'll be immediately taken into custody. If there's a dispute about it, then we will certainly have it sent to the lab. If he's on any prescriptions at this point in time, that would mean that Mr. Chair would need to be turned over to the county probation so they would know what to look for.
Yes, Your Honor.
I'm trying to think what's on that longer bond order that we do, ma'am. Can you get a copy of it?
Your Honor, a couple of things, and we will pull one up just to clarify on the conditions. Of course, we would request waiver of extradition.
Yes.
A curfew as to Mr. Hyde, when would be appropriate hours. Obviously, he's not going to be working in the middle of the night, so we would request at the latest an 8 p.m. curfew.
And again, he would only be if he's working with Mr. Hyde. In other words, he can't. Mr. Hyde now has a shadow on him. That would be if
He will be supervised.
And I realize sometimes you're in construction, particularly when the weather time changes, and they may be working at 8 o'clock. But he can't go to the grocery store with his mama, he can't go to church with, Mr. Hyde is testified under oath and is willing to come into court and put up his wealth, Mr. Stokozik, so then he must be willing to let basically the stepson to be with him unless he's at home. If he is not working or church or medical appointments, he's got to be at home, period. No trips to Walmart, no trips to the grocery store. We're talking about working or going to church if they do. I'm not ordering them to go to church, that's their decision, not mine. Or medical appointments, so even if it's a medical appointment, Mr. Hyde must be the one taking him.
At all times, he is not located at 335 Queen Road. He shall be supervised by Mr. Hyde. He would be permitted to leave for the purposes of church, medical appointments,
And work.
work, and also for appointments with his attorney as well.
But that would be Mr. Hyde bringing him to appointments. I'm putting the burden on Mr. Hyde. Mr. Hyde is going to testify before me, and appears he doesn't have a criminal warrant, and he's putting up $50,000 bond, so he has a real interest in this case. Well, he's putting up 25, Mr. Patterson putting up 25.
Your Honor, additionally, we would request out of an abundance of caution to ensure the location of Mr. Chamaty, that he be fitted for an ankle monitor before he be released from custody.
No.
May we include general conditions such as that he will obey all laws of this
Yes,
county, state, municipality, and federal government.
yes.
Also, as to requests regarding, obviously, his contact as it would relate to co-defendants, we would request that he be ordered not to have any social media accounts, and that he not have any, of course, as you had said, internet contact, but we would like to try to limit the method in which those contacts would
There
occur.
should be- What I'm saying, there should be no direct or indirect, other than if they're in court together, between him and any of the other co-defendants, period. That's what got him in trouble to begin with.
He will not possess or consume any illegal controlled substances or alcohol, as he would be on the color wheel, correct?
No firearms or any weapons of any type.
And then upon a violation of these conditions, he would be taken into custody immediately, is that
Immediately, then
correct?
Mr. Steele could ask for a hearing. In other words, he shows up for a drug screen, he tests positive for anything, he's going to jail, then Mr. Steele will be notified and they can have a hearing after that, but he will go to jail. Or if there's any other violation that occurs, including, he's working somewhere and Mr. Hyde's not there, that's a violation.
And as to the bond, you indicated that Mr. Hyde and Mr. Gerald Patterson would sign on those bonds. Is the court
It may be that Mr. Hyde will do all 50,000, but the only other people that I heard from is Mr. Patterson, so I don't know if Mr. Hyde owns his home or other property. He may have said I didn't write it down, so,
and that would be cash and or property bond, Your Honor?
yes, ma'am.
That's all from the state.
Is there still any questions about it?
No, we understand. Thank you, Your Honor.
All right. You were here when Ms. Sosby stipulated the facts of the case. I'm assuming it is not necessary to rehear those.
Correct, Your Honor. It may be a significantly shorter hearing in regards to my client. I believe the state would concur that I think that what essentially the state argued for Mr. Steele's client is similar in the nature of my client's involvement as well. I can proffer to the court. I think everyone here is in support of both of these gentlemen. They grew up together.
No, I would need to hear some evidence of where he's going to
Of
be.
course, Your Honor.
And what their records are.
Yes, sir, Your Honor, but I just wanted to let you know that part of it. I have his father here in court, and of course, if that's not satisfactory, we also have a couple other options for living arrangements with him also as well.
But you, are you agreeing there's no need for Ms. Sosby to proffer?
Yes, I agree with that. Sorry, Your Honor. Yes, ma'am.
Your Honor, before we begin the next bond hearing, could I possibly have a 5-minute recess?
You know.
Thank you.
Yeah, we'll be in recess, but I know we're going through lunch, but because of other matters.
So, Your Honor, I didn't want to leave without the court's permission. And the bond order, make sure they were going to email it to me. I gave them my permission if it needed to sign my name.
All right.
And then if this on the court thinks that it is in compliance with the court's order, then the district attorney wants my client to sign saying. I was going to just tell him that it's okay if a law enforcement official presents that to him to read it. I was not going to be here.
At the Fannin County Jail?
Yes, and just make sure that he would sign it, and then the prosecutor told me they would, once it's all done, they would file it and email me a copy, and I appreciate that. With that being said, may I just speak with Mr. Chamaty just for a moment outside the court's room and tell him that?
You may.
And then may I be excused?
Yes. Do you know yet, is Mr. Hyde putting that directly in the family?
May I turn my back one second?
You may.
You have property?
Property, yes.
Mr. Hyde believes property, Your Honor, if that's okay with the court.
But even though he may have another 50,000, I still want Mr. Patterson's name on
Mr. Patterson, you understand that? Your name will be, you ought to sign the bond as well.
Yes.
And you'll both stick around for a while?
Yes.
Thank you, Your Honor. And Your Honor.
it. Now, I want to do this as well, Ms. Susby, in the event which occurs, that even if he is indicted for additional charges, this would be the sole bond.
Yes, Your Honor, and I had previously discussed that with Mr. Steele regarding presentation to the grand jury, and if there were additional charges, because it is our belief in the event that the grand jury were to true bill the felony murder charge, that would be the controlling charge against the defendants on the indictment.
Your Honor, can I ask one other thing?
You may.
And I will tell Mr. Chamaty what happened here. I know it's not correct, but I promise you I'll tell him exactly what happened. Mr. Hyde told me he will follow every condition. He does work right across the state line in Tennessee. I believe he called it Polk County. He wants to know if Mr. Chamaty can accompany him across the state line. If not, he said that's fine, but he wants to make sure that the court is aware that he does have work at times in Tennessee.
How often are we talking about?
Not very often, ma'am. Once a month, maybe once every 2 or 3 months. I do subcontracting tile work, so if it's a homeowner that lives in Polk County, then I would go there to do that job. And generally, they're a week long, and the job would be done.
Okay, we've got the waiver of extradition.
Your
Ms.
Honor,
Susby, what's your position on that?
given the fact that the court has granted a bond, but specifically in one of the provisions being that he not leave the state of Georgia, we would request that he remain within the confines of the state.
So he would just be home that day?
That's fine, Your Honor. Thank you.
Who would be home with him? I just realized that he's home.
No, and his mother works as well, Your Honor.
Well, as long as you understand, if there's information presented to the court that he's outside of the home or seen in Blue Ridge or somewhere, and you're not with him, then I'm gonna revoke his bond, and he'll sit there until the trial.
Yes, ma'am.
And the reason, with all due respect to you, and I don't think his mom or his grandma don't like to hear this, but in every one of these defendants, these children are basically let go in their entire life. Which we don't do that as parents. And I know you're a step-parent, but I mean, none of this should have never occurred, because somebody should have known where these kids were. And frankly, particularly for the ones that are 15 and 16, their parents, I hope they understand this court finds that there's a huge responsibility that they had not knowing where their children were, and two living here and two living here. That's not how we raise children. I think every bit of this could have been prevented if the parents were just exercising what they should be doing as parents to begin with, which is knowing where their children are on a school night at 1 o'clock a.m. in the morning. So I know I'm maybe preaching to you and your step parent, but on the other hand, I have been a step parent, and I knew where they were at 1 o'clock in the morning. So if he's out in the community, and I don't care if he walked over to the church and he's there and you're not with him, then I'm gonna revoke his bond and he'll sit there. So I don't want anything else to happen with these, and he's 20, he's older than the others, although he was hanging around with the others, which is in itself sort of strange. But someone has got to be with him and make sure that he's at home doing what he needs to be doing. So, if you're not gonna be there, you may wanna have someone there to make sure he is there, because it's gonna be you that if he doesn't show up, that'll be losing $50,000 in property.
Yes, Your Honor.
All right.
Thank you, Your Honor.
All right, any other questions, Mr. Stewart?
No, Your Honor.
All right,
May I be excused?
you may, thank you.
Thank you so much.